I think it is to the credit of the law department in UCC that you have chosen to put on this very interesting topic. Most law functions are concerned with areas of law, but of course, the delivery of real access to justice in real courts is as vital to a properly functioning civil society as the laws which the courts are to have to enforce. I might start with a story. I'm sitting here in my office in the forecourts, and just outside the door is the area where judges assemble before they go in to sit in the Supreme Court. And on the 12th of March, we were assembling to hear an appeal in a case which happens to be called Bank of Ireland and E-Teams. And my secretary, who also occupies that space, had the radio on. And on the radio came the voice of the Taoiseach speaking from Washington to tell us all that times are going to be very difficult. It's a striking fact that since that day, the Supreme Court has not sat in that courtroom. It's been used for a few ceremonial occasions under very limited attendances, and we have only sat once at a physical hearing since that time, and we had to use the main hall in King's Inns because we needed much greater space. And it's interesting to reflect that that is still well within a year from where we are today, and so much has happened in that time. And I'd just like to outline the course of events and what I think are the more important features of what's happened in that time in our attempt to keep as much as possible open in our courts during the pandemic. The very next day, which it has to be remembered was Friday the 13th of March, there were active discussions between each of the 5 court presidents, the presidents of each of the tiers of our courts, and joined from time to time by senior managers from the court service. And indeed, that group of people, the court presidents as the judicial administrators, if you like, and the senior management team from the court service as the civil servant managers, have formed, I think, a coherent group, perhaps to a greater extent than had existed in the past. And that may be one of the many beneficial long-term effects of our response. But essentially, the decision that was made that day was that we would have to move immediately to a situation where we would only conduct urgent court business. And of course, there are many types of court case which just can't be not dealt with. If people are arrested, they have to be brought before a court. As I pointed out at the time, domestic violence doesn't stop because there's a pandemic and people need access to a court. And indeed, some research would suggest domestic violence is more prevalent during lockdown and pandemic circumstances. So the collective made a decision to move to urgent business only, but it was left to each president to decide within their own court what areas needed to be prioritized, what could be done safely, and how it could be done in conjunction with the relevant managers. So that was the initial response. Probably like a lot of the country, it was closing a lot down in circumstances where we hadn't any great experience about how we would go about either opening it up again or even managing it during those difficult times. And I have to say, there was a lot of pressure, I think, from not least the practicing professions to close down as much as possible because people were frightened, and legitimately so. And I can't say that the closing down happened perfectly. There were undoubtedly incidents in the early days when there were more people in courtrooms than probably should have been there. And I'll come back to that topic in due course, though I did say at the time, and it's perhaps been proven more right than wrong, that closing things down is easy, opening them up again isn't quite so easy. And my judgment at that time was that this would last for a lot longer than many people were suggesting, though I would have to say even I didn't think we would still be where we are come the run-in to Christmas. That initial decision obviously continued to inform the way the courts worked during the initial lockdown period. It was tweaked from time to time. And I know Oonagh may speak about some legislation that was passed a little later to facilitate certain types of hearings being conducted in a more efficient way. Though one of the earliest moves that was made was to attempt to move certain kind of hearings to a remote platform. And that, I think, has broadly been successful. I'll make a few comments about that in due course. But that position was maintained for some little time until the government plans for opening up society emerged. And if you recollect, there was a phased series of openings up. We had been planning for what we would do during that opening up period. And we moved from a situation where we decided in principle only to deal with urgent cases to a situation where it was our desire to hear as many cases as possible in a way that was consistent with safety and also with government regulation and recommendations and guidance at that time. And again, that principle was agreed on at a high level between the presidents and the senior management team, but its practical application in each court was left to the individual presidents, or perhaps even judges who were in charge of particular areas in conjunction with relevant managers. But there were, and continue to be, significant limitations and challenges. And I'd like to discuss some of those and the lessons that they may have for the future. Firstly, we have our stock of courthouses and courtrooms. They weren't designed with the pandemic in mind. Many of them are not easily used in conditions which are necessary for particular types of cases. And we've had to juggle with the way in which courtrooms are used. But at least courtrooms are relatively easy to control. At a very early stage, we had our health and safety people look at each courtroom to decide the maximum number of people that could be safely accommodated in that room in accordance with the relevant rules, 2-meter distance and the like. And indeed, in some cases, we've managed to move around furniture, which has allowed extra people to fit in, because sometimes you couldn't get someone at 2 meters, you could only get them at 3 meters, but if you moved the furniture, you could bring people closer together, but still within the distance. But courthouses are perhaps an unrecognized and larger problem. If you overburden the courthouse, then the danger may not happen in the courtroom, but it may happen in the environment. So if you have a very large number of people coming in and out, even though they may be safely accommodated in one courtroom or courtrooms if they're running simultaneously, if you overload that, you may come to a situation where you have a very dangerous courthouse, and it's harder to control the general circulation areas than it is to control the courtroom. And that meant really that we couldn't, in the bigger courthouses like the Four Courts, but also the large courthouses in the major provincial cities like the 2 large courthouses in Cork, we had to be sparing in ensuring that you didn't have all the parties and all the lawyers for a series of cases arriving at the same time to go into different courtrooms where they would be safe but unsafe in the courthouse itself. And in that context, I think the growth of the use of remote hearings was also important. The way I saw it was a remote hearing was an extra hearing. It freed up a courtroom that was not being used for more than a couple of people, perhaps a court registrar and the like, and therefore wasn't placing a burden on the courthouse, so that other courtrooms could be effectively used for cases that were not suitable for remote hearings. And I think that's perhaps not a widely recognized but important part of the challenges and the way we have sought to meet them. We have sought out additional premises. One of the areas that was particularly difficult was the area of jury trials, because by definition, there's a lot of people at a jury trial. You have the 12 members of the jury, you have the judge, you have registrars, you have lawyers, you have the accused, you may have victims and others. So the number of people that need to be there for a jury trial is a lot larger than many other types of cases. And in fact, at the beginning, we managed to finish all the jury trials that were at hearing, but no new ones were started. But by September, we'd worked out methods. But for example, in the criminal courts of justice down the river here in Dublin, we need to use 2 courtrooms for every jury trial to accommodate all the people. And that's meant we've had to look for additional premises. And we've used various places. And I think we're about to use after Christmas Croke Park, when the All Ireland series is finished, which can accommodate quite a few criminal jury trials. We use external premises for cases where the accused is not in custody, is on bail. We use our own secure premises for custody cases. And for example, in many of the non-Dublin venues, we've had to hire a hotel, for example, for the jury empanelment, because there was no safe space within the courthouse where that could be done. And what essentially happened was that our senior managers identified those courthouses which were capable of having a jury trial conducted in them, sometimes with assistance from a local hotel hall for jury empanelment. And we had to move things around so that the Central Criminal Court, which normally sits most of the time in Dublin, was actually sitting not only in Dublin, but in other places. And circuit criminal trials, which normally take place in the county of the alleged crime, were being moved around again because there were only 11 or 12 courthouses in the country that were assessed as being suitable for jury trials. Witness actions were also more difficult to get going again. The kind of cases like, for example, judicial review, certain kinds of insolvency cases and the like that don't involve witnesses, where the evidence is normally on affidavit, are easily conducted remotely. And even if not remote, they don't require a large number of people. Witness actions do. And in particular, witness actions with more than 2 parties, where you will have legal team, you'll have the witness. For example, if it's an expert witness, a doctor or an engineer giving evidence, well, the other side's equivalent witness will wish to be in the courtroom to see that evidence, so they know what evidence was given when they come in turn to give their evidence. And there's been some difficulties about just how we can manage that, but we did get witness actions up and running from September, and I think did so successfully. I know there have been some practical difficulties. For example, typically students in King's Inns and the Law Society will want to visit courts as part of their training to see what happens in a real courtroom. And it hasn't really been possible to allow that at this time, because most of the witness actions that are running are using up the entire capacity of the courtroom. And equally, young apprentice barristers, devils as they're called, who would again normally be there as part of learning their trade by seeing how experienced barristers conduct cases, while there's no reason why they can't go in, they're finding a lot of the time they can't, simply for numerical reasons, that the people who have to be in the courtroom have used up the full allocation of spaces. And we're looking at ways of dealing with that. But unfortunately, if safety says you can only have 11 people in the courtroom, you can only have 11 people in the courtroom. The virus doesn't know that you're a King's Inn student or a devil, and it won't allow an extra 3 in and say it'll be hands off on this occasion because we need to let them in. We're stuck with that kind of situation. So we from September onwards, we were operating, having a fair number of witness actions, not as many as we would traditionally have had, but quite a few, reasonably close to a full complement of jury actions, again, not quite at the level we were, and a greatly expanded use of remote hearings for the kind of cases for which they're suitable. And in some areas, the judges also developed what came to be known as a hybrid hearing, where some of the people would be in a courtroom, but some, perhaps witnesses or others, would be accessing that court hearing from outside. The way in which we kept the obligation to administer justice in public going was that every remote hearing has a courtroom which is open to the public and has a big screen in the courtroom showing exactly what the people who are participating remotely can see. So you can sit in the Supreme Court any day, we're conducting a remote appeal, and you can see all of the judges, what their contributions are, what the submissions of counsel are. So you get as good a view by sitting in the courtroom as anyone else who's involved remotely. And I think other than in those cases which are properly held in camera, there is that level of access. Now, obviously at certain times, it may not have been possible for people to travel to a courthouse, but they had as much access to the remote hearing as they would have had if the case was going ahead as a physical hearing. We also have greatly expanded the use of online measures to facilitate things that would sometimes, perhaps unnecessarily in the past, have required people to be present in court. Many court documents can now be filed electronically. I think some of us are of an age where we still like to have the key documents in hard copy in front of us during the hearing. And the practice now in the Supreme Court is that if it's a big document case, it'll all be filed electronically, but hard copies of the central documents that are likely to be referred to in the course of the hearing will be filed in that way. We're also allowing, for example, consent orders to be done online, rather than lawyers having to turn up at the beginning of the court hearing and say, item 15 has been agreed and you can make whatever order has been agreed. That can all be done online. And they're part of the evolution, the rapid evolution that's occurred, which I think will have a permanent feature into the future. In terms of remote hearings, I'm not sure they will remain as a central part of full cases, appeals in the appellate courts, full trials. Hybrids, maybe to some extent. They're not as good as having everyone in the room. We find, for example, in the Supreme Court, that the cut and thrust between the court and counsel is not easily managed on a remote platform. What's effectively happening most of the time now is the questions wait till the end. Now, it might be easier for counsel. I remember in the days when I was the other side of the bench, part of the challenge was finding questions being fired at you from all corners of the bench. But none, and I think that is a valuable part of the process, that sort of intense questioning. So I think others may have a different view, but my view is for the full hearing of an appeal, it will be better when we can safely to go back to physical hearing. But there are many things that we've learned that I think can still be done remotely. For example, case management has become a major part of the conduct of cases in various courts, not least the Supreme Court. Making lawyers leave their offices to come to the forecourts for a 7-minute hearing to sort out some procedural issues or the documentation that needs to be filed for an appeal is a waste of everyone's time. Those things, I think, will probably in the main continue to be done remotely in the new normal. And that's the last thing I really want to comment on. What have we learned and what elements of this will form part of the new normal post-COVID? I know Oonagh Buckley is going to talk about some elements of the future. I won't steal her speech at this stage, and I'll let her explain those. But I think there's a whole range of things, from the new family court structure to the court services modernisation programme, Peter Kelly's civil procedural review and others, which have been in planning for a long time. And the way I see it at a general level is we've now finished the planning stage and we're moving to the implementation stage. And I think there's a lot of change coming over the next number of years. And I very much welcome each of those strands, which I think collectively will allow us to build a much better court system. But what have we learned during the pandemic that may feed in to that process? Firstly, I suppose we did a lot of things a lot more quickly than we probably would have done had we not been forced to deal with them quite so quickly. We now know what works. We know what might work with a tweak or two, and we know what we don't think works so well. And I think that will inform a lot of the implementation of the new procedures. The new normal will, I think, be very different from the old normal, and we will have accelerated our move to that new normal precisely because of the pandemic. So I think while it's made everyone's life miserable in a whole range of different ways, and it's created very great challenges for maintaining proper access to justice, I think there will be some positives from it, and there will be things that we will be able to do with much greater experience than perhaps might have been the case in the past. It's led to new practices, for example, many of which I think will survive in the post-COVID era. I'll just give one example, but very many more could be given. The Supreme Court had been thinking for some time in the past to develop a practice whereby a document would be issued after the parties had filed their written submissions, but before the hearing, which set out not a preliminary view on what the answer was, but the court's view on the questions, as it were. Set out the facts, set out what happened in the High Court or the Court of Appeal, set out the issues that the parties have raised in their written submissions, more or less setting the picture for the oral hearing. And also, I think, probably doing some of the donkey work for the judgment at the end of the day, because much of that material is not controversial in the sense that the hearing in the High Court has already happened, so it's not going to happen again. And therefore, being useful for the parties and also perhaps useful for the court in that if the court is under a misunderstanding about something, the parties are invited to comment on the statement of case and say, well, actually, we don't think you're right in paragraph 17. And it allows for any errors of apprehension on the part of the court to be corrected in advance, rather than the judge including something in a judgment and then being told afterwards that that was wrong. It kind of cures that in advance. And that practice, as I say, we were thinking of doing for a number of years, but other things got in the way. But we decided to use the opportunity when we were not having any hearings until we got remote up and running to invoke that practice. And it's now a more or less universal practice. And I think it's very useful in focusing the hearings and also has probably speeded up the gap between the hearing and the delivery of the judgment, which is a good thing as well. We've learned a lot about remote platforms that I think will feed into those areas which will remain remote post-COVID. We were very pleased, I think, that we were able to get remote hearings up as quickly as possible. You know, I talked about the 12th of March. It was in late April that the Supreme Court began dealing with matters remotely. So I think that's a fairly speedy response. But the way we were able to do it was to use a platform we already had, which perhaps isn't absolutely ideal, but we've learned from that and we're able to now specify exactly what kind of platform would be ideal for the immediate future, during the remainder of however long there are COVID restrictions in place, but also in the new normal thereafter. I might end with just another small story. Near the beginning, I was asked in my role as chair of the court service to record a message of thanks and encouragement to our staff. And I think I should say that the court staff have really excelled during this period. There has been no difficulty in getting people to do things differently and come up with innovative ideas about how things might be worked in a better way. I could go on, though Angela Denning, the chief executive, could probably go on even longer about many of the things that were done. But in the course of that recorded address, I posed the question as to whether when it's all over, we would think we got everything right. And I said the answer to that is almost certainly going to be no. We were making decisions quickly. As I think I put it more or less this way, the virus isn't going to wait for the working group or the implementation body or the committee to work out a detailed way of doing it best. We're going to have to do the best we can and to make decisions in hours and days that would normally take weeks and months or perhaps even years. And clearly doing it that way means some things were got wrong. But I'd like to think we got a fair amount right. And I'd like to think we were prepared to correct where we did get it wrong. And perhaps most importantly for the future, to feed into these new things that Oonagh Buckley will speak about, which were going to happen anyway. But I think many of the lessons we've learned, either in getting it right or in getting it wrong, or a bit of both, will feed into that process and will mean it'll probably be quicker in its implementation and also potentially will be better. So that's a potted history from a court's perspective. I think now over to Oonagh, who has a wider perspective, not just in respect of the courts, but also the wider justice sector. Thank you very much.
Thanks very much, Chief Justice. I'll now hand over to Oonagh Buckley.
Thanks very much, Dean, and thanks very much, Chief Justice, setting the scene very nicely. And unfortunately, I'm probably going to let everybody down now because my perspective is not, as I say, exciting to many of the court participants present. So I want to speak to three different themes. Firstly, to how our responses as a justice sector, I should say the department always thinks of the sector as a whole, as links in a chain, rather than trying to think of each entity separately. And how our responses have evolved from what I think the Chief Justice has fairly described as the very reactive responses of the first few weeks, which led to only emergency justice being available, to the support of wraparound of today, where we're impaneling juries, or the courts are impaneling juries, even at level 5. Secondly, I want to talk about some of the whole of sector endeavours which were led or supported by the department, and that aimed to deal with the biggest challenges of ensuring the safety of people in Ireland in the midst of the pandemic. And thirdly, as the Chief has said, I want to speak about some of the ministers and the government's priorities for the future and the implications that those have for the courts. So just to say, again, starting with a little anecdote, I have, in lieu of the minister, spoken at 2 OECD conferences on the subject of how we're managing to deliver justice in the midst of the pandemic. And the conferences were held in April and October. And I reread the speeches as part of my prep for today, and I was amused by the huge shift in our language and descriptions between April and October. The first conference, which was essentially by senior officials, very few ministers present, essentially showed that Ireland's initial response within the justice sector of being completely unprepared for a pandemic in the court system was not at all remarkable. Almost every country present, particularly recall the Canadians saying, it was like, you know, it was horrific what happened, because everybody had the same problem. Processes that were paper-based, based on close and regular contact between large numbers of people and on large numbers congregating in or around courts buildings. So there's the same problem across the world. But by October, all countries were reporting substantial changes to how justice was being delivered in their countries, and Ireland's experience, therefore, was far from unique. As an initial reaction, the two governance functions of the Department of Justice, and again, slight aside, last year, the Department of Justice was thoroughly reorganised to move to along the lines of a functional model where what we do as opposed to what we know defines our jobs. We're the only government department that's been reorganised in this way. I think the others are waiting to see if it works. But one of the huge benefits is that we have two units whose job, or two areas whose job is solely to manage how we relate to the entities within our sector, both on the criminal and the civil side. And they, therefore, were in position to act quickly to establish some cross-government structures which address the significant challenges brought about by the pandemic in the sector. So we established these two groups, COVID-19 working groups, with senior officials from within the department and from the key agencies. And these structures allow the department to work closely with all relevant criminal, civil justice and public health agencies to adopt measures that are in line with public policy and the evolving situation, and ensures that they can work closely together to deliver solutions. So this also allowed us to feed actions and activities happening in the justice agencies into the central coordination units managed by the Department of Taoiseach. And likewise, we could feed information and instructions, say on we're moving to level X, or on personnel matters, for example, how do we deal with home working, down to the agencies, including the court service. It also helped to ensure there was no surprise announcements. And I would say that the initial few weeks, the court service did move quite fast and maybe a bit ahead of the rest of the public service, which caused a little bit of angst, it should be said, not just in 51 St. Stephen's Green, but indeed in government buildings. So where there was, after those initial stumbles, the system has worked quite well. And what it allows as well is to use the central systems to amplify messages. So for example, when the District Court President Colin Daly, it clarified that parents could come to mutually agreed arrangements for alternative contact on communication by phone, by Skype, but that COVID could not be used as an excuse not to provide access to children. We fed that, we were pre-warned about that. We fed that message into the centre, and then that could be amplified by the Department of Taoiseach's daily briefing. You all recall Liz Canavan standing the plinth every day, telling people messages about what was happening in the pandemic. So that in effect, that structure, it probably sounds very structure heavy, but actually it worked very effectively for the passage and for proper communications, which was key to the management of the crisis from the government perspective. In the initial days and weeks, those groups met very frequently, even daily. For the first 6 weeks of the lockdown, I had an internal or external COVID management meeting every single day, including Saturdays and Sundays, and often many of them. In fact, the only way I could distinguish Sundays from any other day for a large part of the first lockdown was that my father insisted on watching Mass on Facebook. So I had at least something that grounded me. It was definitely Sunday. I did the lockdown with my father, as an aside. Subsequently, as matters stabilised, we began to meet weekly, and we now meet fortnightly on each side. The court service uniquely attends both meetings, and of course it has to, because they have criminal court functions and civil court functions, so they have to be in both places. There was a very high priority set by government and set by the then minister that the courts had to keep working. They had to keep open, at least for the most urgent work. So there was a little bit of tussling because of that initial reaction outlined by the Chief Justice, where people were afraid, and rightly so. At the same time, we understood, and it was made clear to us that the court service were focused on reducing the throughput of human beings through the buildings as much as possible. So, and I know the Chief Justice has spoken about the urgent matters that were kept going, and I won't repeat it, although we were very pleased that the existing jury trials, including critically a capital murder trial, were continued and brought right through even during that first lockdown, and were completed, which was great. A huge swathe of court-related work, legal work, obviously just stopped, and the legal professions suffered a very large drop in income, a very significant one. And we've been briefed on that by both the Bar Council and the Law Society. So, as some support, the department made arrangements to pay criminal legal aid brief fees to solicitors and the full fee for the first day of appearance in court to counsel in respect of all trials and hearings which had been scheduled but adjourned because of COVID-19 in that first phase. And we also saw a very large increase in legal aid claims, civil legal aid arriving from solicitors' firms, presumably maximising their available income streams. So this stuff has been down the back of the sofa for a couple of years, It was quite tricky to deal with because of our own requirements to reduce our people's numbers in the buildings. But thankfully, our financial team, who are based in Kerry, in effect went to work every day, even during the first lockdown, because they had to, not only to deal with this increase in claims, but also because they paid the Garda Síochána's wages. So it's quite critical that they kept going to work. So thankfully, obviously, with work recommencing to the levels outlined by the Chief Justice, that level of sort of support isn't as necessary now. And we also knew from the countries that had experienced the lockdown ahead of us that one of the side effects is a surge in domestic abuse. In March and April, the department developed an interagency plan to address the heightened risk of domestic abuse. We gave additional funding, nearly 200,000, to community and voluntary groups in the sector. Garda Síochána established a proactive, targeted policing initiative for domestic abuse victims, with particular attention to the people who'd come to their attention before as victims. And the court service and the legal aid board gave priority to domestic abuse and childcare cases, and the legal aid board established a helpline, which was really useful. And the then ministers, Charlie Flanagan and David Stanton, launched a public awareness campaign on the issue with TV and radio ads that let the victims know the services are still available to them at this time, which hopefully you've all seen. That campaign actually has recently been relaunched, as sadly our initial statistics are clearly bearing out the fears of a substantial increase in crime in this area. And the other response, obviously, as outlined by the Chief Justice, was the widespread and immediate cooperation between agencies to use technology to reduce footfall and the need for movements of people. And I have to say, giant steps were taken in terms of the use of technology over those first few weeks with the cooperation of all parties. And I want here to acknowledge the great leadership of the judiciary, who in some cases, in the absence of primary legislation, and indeed any way on our part to pass legislation with the caretaker government, issued practice instructions to underpin the legal use of these measures. So just to take one example, from March, we went from a very small number of prisoners appearing for preliminary matters by video link from prison to the vast majority of experiences from prisons for all people currently in custody. And if you think about the numbers of movements of people that eliminates, instead of prison officers, of prisoners, of the guards, and of courts personnel moving around, interacting, and potentially bringing the virus back into the highly vulnerable prison environment, the use of video links just eliminates the whole thing, eliminates the risk entirely. So it's a really positive development and one we would very much like to retain. Saves us quite a lot of money on moving prison officers around as well, just as a side effect. From April and May, then our thoughts were turning to the measures that we needed for the justice sector to resume a broader range of work in a way that maintains the safety of participants while allowing their justiciable problems, particularly in civil and family matters, to be determined. We also wanted to maintain momentum for technological change, to take advantage of this crisis and the momentum it had created, with the change of mindset that also needs, as well as the necessary investments in technology. We also knew that a certain level of legislative support would be needed for this to permit things like e-filing. So I've mentioned we were in a difficult position in the spring of working to a caretaker government who did not feel they could commence any legislation other than amendments to deal with the pandemic. And then in the absence of a full Seanad couldn't legislate at all. But to be ready for when the government formation talks would conclude, and alongside the judiciary, the court service and other agencies, we started to work on the proposals that were subsequently included in July's Criminal Civil Miscellaneous Provisions Act of 2020. We established yet another round of cross-agency groups. Governments are built on meetings and working groups, which we call the medium-term planning groups. And critically, members of the judiciary participated in these groups, and therefore were able to raise specific issues for the policymakers in the department to consider, and if necessary, make proposals to address those concerns. And those groups, which again met very regularly in the beginning, now meet on a quarterly basis, and that keeps the engagement between officials and the judiciary on this key job, which is keeping the justice system moving in the context of the pandemic. I should say that despite the Zoom overhead that these meetings entail, I personally value and welcome the engagement with the judiciary in problem solving around the courts. I respect, of course, that the judges have an entirely different role constitutionally to us civil servants. But policymakers cannot know what problems they have to solve unless the people with the day-to-day knowledge of the system tell them what they are. So when the government was appointed in late June and significantly assisted by the dynamism of the newly appointed Attorney General, on the 20th of July, the government approved the priority drafting of the general scheme of the Civil and Criminal Miscellaneous Provisions Bill 2020. It was passed by end July, it was very quick, and it was brought into force with the exception of one section in 2 tranches over August and September. And the Act included the most urgent provisions necessary to ensure the courts could keep operating in the context of the pandemic. So that's provision for electronic filing of documents in civil matters and for the statement of truth to be made and transmitted electronically. An amendment to permit the court to take account of any unreasonable refusal or failure by a party to participate in a remote hearing when awarding costs in a case. Amendments to the Prison Act to extend the types of hearing that may be heard by video link. To include trial, arraignments and sentencing hearing, extend the use of video link to include applications in relation to surrender proceedings under the European Arrest Warrant and the often used International War Crimes Tribunal Act, and amendments to the Criminal Justice Administration Act of 1914 to allow for outstanding committal warrants to be executed in prison where the prisoner is already detained. And one of the harder aspects of the pandemic, it also made changes to the Coroners Act to allow for extra capacity in the coronial system, but we haven't had to tap that yet, thank God. There will be need for more, and we are planning for further miscellaneous provisions acts in both the criminal and civil sphere for next year. I want to briefly mention policing, and I appreciate, Mark, I'm probably running over time, so I'll keep going until you start waving at me or muting me. So
you're fine. I mean, please keep going for a couple of minutes. You're still within your 20 minutes. Don't worry, Oonagh.
Great, thank you. So in light of the urgent need for protection of human life and public health, some restrictions on movements and gatherings have been provided for and associated enforcement powers provided for on Garda Síochána. And those regulations under the 1947 Health Act, an act that has stood up remarkably to the pressures of being used to manage this pandemic, given it was needed for, I think, to manage tuberculosis back in the day. So those are renewed or adapted depending on the level of restrictions involved. In fact, they're often redrafted on a weekly basis, and there's been a huge amount of input by Justice to help health just to manage, because obviously the Department of Justice has a huge legislative base. We know how to write legislation, so we've done a lot of work with them. So the latest iteration, signed on Saturday, includes fixed charge penalty notices for people organising or attending indoor events in contravention of the law. So no birthday parties. The Guards, of course, have the tradition of policing by consent, and it was felt critically important to preserve that tradition, even in the context of much more extensive policing powers than is usual or normal or desirable in Ireland. As they went about their business in supporting the COVID-19 public health measures, Gardaí adopted a graduated response based on using what they call the 4E approach. They engage first, they explain second, they encourage third, and they enforce only as a last resort. And in the interest of public confidence and to ensure the new Garda powers are implemented in a human rights compliant manner, the Minister for Justice requested the Commissioner to compile and publish a record of any use of the powers, and also has requested the Policing Authority to report regularly the use of the powers. I encourage you to read the Policing Authority reports. They're actually quite interesting, including things about the use of spit hoods and all that sort of stuff. Broadly speaking, they show quite a positive response to the use of the Garda powers and to that moderation of its policing response. And even in the case of certain communities who would not have had a positive view of the Guards generally, I think maybe particularly the traveller community, for example, they report being appreciative of the additional interactions the Guards are having with them as part of the pandemic response. So that is a positive that flows from this, and one that hopefully we'll be able to maintain. So finally, part of the job of the civil service is to try to think and anticipate what will be coming up in a year's time and try to ensure that we're ready to meet that. And one of the things we're thinking about now is the downstream effects of the pandemic. So I've already mentioned one social effect, domestic abuse. We are also anticipating a big increase in relationship breakdowns, and being locked in your house with the other half for months at a time with only WhatsApp to break the monotony could end any love story. So an increase in family justice needs is on the cards. And that will impact practitioners, the courts, the legal aid system, and surrounding supports. Unfortunately, we are not as ready for this as I would like to be. Minister McEntee has published the heads of a bill for a family justice system in September, and we have established a group, once again with that valuable judicial presence, to oversee progress on the parallel changes as the legislation is drafted over the coming year. But realistically, given Oireachtas scrutiny and the other preparations that will be needed, it will be 2022 before that legislation has any real impact. But hopefully it will start to come into play from then. We're also anticipating an increase in insolvencies, with the Insolvency Service of Ireland telling us they expect that wave to hit in the back end of next year. And our insolvency system is relatively up to date, having been thoroughly overhauled after the last recession, but was the subject of the review that will be published shortly. And we will also shortly be publishing legislation that will make certain key amendments to the Insolvency Acts to help accommodate people and businesses affected by the pandemic. That should be published in the next week or two. I should say the Insolvency Service of the Court Service also cooperated very closely to manage the administrative and court requirements for insolvencies during the pandemic, so it was very useful cooperation there. The Legal Aid Board obviously is going to need additional supports, and we have significantly increased funding both for the Legal Aid Board, and I'm delighted to say we managed to treble the core funding we provide to FLAC, the NGO that provides free legal aid to persons needing help with access to justice across a range of areas. FLAC, by the way, have reported to us a big increase in employment-related queries as coming into their phone lines. And obviously we have as the Chief Justice pointed out, the pandemic has supercharged the need for modernisation and wholesale adoption of technology in all areas. And one of the primary roles of the department, as the parent department to a lot of agencies, is to engage with the Department of Public Expenditure, my former colleagues, on budgetary needs for the sector. And with our support, the Court Service has benefited both from COVID-related capital stimulus spending over 2020, which is helping them to fit out those new venues for socially distanced trials that the Chief Justice spoke about. And in the budget for 2021, as well as additional COVID spending, we have secured extra current and capital funding of the order of 8 million to specifically help the Court Service start delivering on their modernisation programme, their digitalisation plan. And so the aim of that is to deliver a user-centred, digitally enabled court service over the next 10 years. Finally, talking of case management, we will shortly be publishing a report on civil justice reforms prepared by the group led by the former President of the High Court, Peter Kelly, and that sets out a very long menu of work for us and for the court service along the broad scope of the civil justice arena, with the aim of making the court service more effective and the process of accessing civil justice quicker, more predictable, and hopefully therefore less costly to litigants. And we will be preparing an implementation plan in the new year, setting out how we intend to proceed. That report is going to government in the next few weeks and will be published thereafter. I should also mention that draft legislative proposals to help ensure that as many matters as can be resolved pre-trial in both civil and criminal cases is also well advanced. And since I know the Chief Justice will be listening for it, I should also note that we are working on establishing the working group on judicial numbers and on new proposals to modernise the judicial appointment system based on the commitments in the programme for government. Many of the reforms I have mentioned, for example, on family justice, will need extra judges and a mandate to manage cases effectively if they are to work well. And obviously, we also need to tackle the backlogs that unfortunately have built up, and those backlogs layered onto a system that was already quite slow in some respects. And it is inevitable as our population grows, we will have a need for an efficient, effective, digitally enabled and well-resourced court system. It is, however, easy, although easier, but not easy, to make a case for those resources if the paymasters can see that the system is working to reform itself too. So it's very useful that we've got all these plans in hand. So there are some bright spots for the future, despite level 5. Thank you.